Thank you. I am calling the Hillsborough County Land Use Appeals Board meeting to order. Today is June 9th, 2023. I am Ricky Bauman, Chair of the Board. We have in attendance Mr. Tom Hisney from Development Services, Ms. Sonia Rodriguez and Patrice Gay from Citizens Board Support. We have Stanley Hind, Jr., Board Member, Shannon Kennedy, Board Member, Peter Schwartz, Board Member, and Daniel Baquerizo, Board Member. Recording Secretary is Allison Desiano. This board is an appellate body and shall only consider the land use hearing officer's decision and the record. This hearing shall be limited to the record on appeal as defined in the Land Development Code and consists only of limited oral argument based upon said record. No additional evidence may be submitted or considered by board members. The order of presentation will be staff's introduction, petitioner's case, opposition's case, rebuttal by petitioner. Only the following have standing to appeal or to intervene in appeal which is filed or may be heard at this hearing: the applicant, the administrator, any person or entity which appeared before the LUHO, the land use hearing officer, and presented testimony or other evidence or presented evidence themselves or by proxy to the LUHO and was adversely affected by the decision of the LUHO. The board reserves the right to limit presentation to 10 minutes per side. This time limit may be extended for good cause. Pursuant to this reservation, the presentation is hereby limited to 10 minutes for each side, with rebuttal limited to 5 minutes. The basis for a good cause extension is that the case requires reasonable additional time. Proposed additional presentation is relevant. Proposed additional presentation is non-cumulative, and the amount of time used to answer the board's questions. The board shall have the authority to uphold the land use hearing officer's decision or to remand the case back to the land use hearing officer. If the board remands a case back to the land use hearing officer, the board shall specify the reason for the remand and specify the issues for the land use hearing officer to address. Ms. Rodriguez, did you want to administer the oath of office now?
That would be the recording secretary.
New members, if you can please stand and raise your right hand.
Just the new members, everybody can be.
New board members.
I, please state your name.
I, Maria,
Do solemnly swear
do solemnly swear
that I will support, protect, and defend
that I will support, protect, and defend
the Constitution and government of the United States
the Constitution and government of the United States
and of the state of Florida,
and the state of Florida,
and that I am duly qualified to hold office
and that I am duly qualified to hold office
under the Constitution of the state,
under the Constitution of the state,
and that I will well and faithfully perform the duties
and that I will well and faithfully perform the duties
of the Land Use Appeals Board, which I am now about to enter.
of the Land Use Appeals Board, of which I am now about to enter.
Thank you both very much.
Thank you.
Ms. Rodriguez, would you call the first case, please?
I'm going to give the oath of witness. Those of you giving testimony must take the oath. Please stand and raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated. First case is on page 2, item 1A. This case was continued from the April 6th Land Use Appeals Board hearing. The appeal number is APP 221514. The petition file number is variance 22-1060. The appellant or the owner is Tony Sullivan. The representative is Jacob T. Creamer and Simone Savino from Stearns, Weaver, and Miller. The petition request is to appeal the decision of the land use hearing officer who denied the request for a variance for a 632-foot reduction to the required separation from an existing community residential home, type A. The location is 401 Mahogany Drive in Sefner. Folio number is 066-883.2256. The size of the property is 0.21 acres, more or less. The existing zoning is RSC-2, future land use REC-6. The service area is urban, and the date of the land use hearing officer was August 22nd, 2022. We have parties here, please come forward. Please state your name and address for the record.
Good afternoon, Jessica Eiserman of 401 East Jackson Street, Suite 2100, Tampa.
Before I let you proceed, I wanted to introduce our Assistant Staff Attorney, Cameron Clark.
Thank you, board members. Just for the record on this application was not, and Ms. Eiserman can speak to this, was not noticed to the other parties of record, and so cannot proceed today. I believe they're asking for a continuance anyway, so we'll let her do that, and then we can address any questions that you have. Thank you.
And is that your request?
Yes. Good afternoon. We are requesting a continuance to your September meeting. We have ongoing parallel conversations with the county regarding a zoning interpretation, which we only received recently, and we plan to appeal that. So considering we have other processes and conversations going on with the county, we think a 90-day continuance is appropriate, and we are hoping to ultimately withdraw the appeal, depending on the outcome of our conversations with the county.
Okay, thank you.
Thank you. I'm available for questions.
Would any board member offer a motion for a continuance?
I'll make a motion to continue it.
Is there a second?
A second.
So there's a motion by Mr. Hine and a second by Mr. Schwartz. Is there any discussion on this motion? If so, then I will ask for a vote. Mr. Schwartz?
Aye.
Mr. Baquerizo?
Close enough.
I'll get it right.
Aye.
Ms. Kennedy?
Aye.
Mr. Hine?
Aye.
And I also aye. The motion carries.
Okay, and board members, for the record, that'll be September 8th at 1:30. And also be advised that because of the specifics of the land development code regarding these types of appeals, if in the future, if other parties are not noticed, this application would just be withdrawn. So if it's not noticed again, it'll just be withdrawn from the docket. That said, it may be withdrawn anyway if they ultimately decide to withdraw their appeal, but we're complete with this one. Thank you.
Thank you, Mr. Carlock.
Thank you.
Thank you. Ms. Rodriguez, call the next case, please.
Next case is on page 3 of your agenda. This case was continued from the April 6th hearing. Item 1B, appeal number APP 23-0067, petition file number variance 22-1373. The appellant and the owner is Alex Omar Wright. The petition request is to appeal the decision of the land use hearing officer who denied the request for a variance for a 2-foot increase to the maximum permitted fence height to allow a 6-foot high fence within the required front yard of the subject's property east side alongside Jackson Springs Road. The location is 8615 Jackson Springs Road in Tampa. The folio number is 007-008.0000. Size of the property is 0.33 acres, more or less. The existing zone is RSC-6. The future land use is RES-4. Service area is urban, and the date of the land use hearing officer was November 21st, 2022. Sir, please state your name and address for the record.
My name is Alex Wright. My address is 8615 Jackson Springs Road, Tampa, Florida, 33615.
Thank you, Mr. Wright. Before you proceed, I want to announce that board members Clara Lorehead and Maria Elena D'Amico are present. Please proceed, Mr. Wright.
And I'll interject real briefly. Sorry, sir. So just to bring you up to speed on this for members who were not here, this application was before your last hearing. No final conclusion was reached because it was a 3-3 vote, which means the application was continued to today's agenda. Because there are members here who were not present at the last hearing, I think it's advisable for a representation of the same thing that went before you last time, so everyone can be appraised of it. And also, just so you know, please, and this was the case last time, please disregard pages 1B5 through 1B10 in the appeal packet. Those are photographs that were entered into the record after the land use hearing officer hearing, and the record that you need to be considering is simply the record that the hearing officer considered, because this is an appellate body, so your function is to make your decisions based on the same materials that were in front of the hearing officer and to determine if there was substantial evidence to support the hearing officer's determination. Ultimately, the way substantial evidence works is that substantial evidence is evidence that a reasonable person could use to conclude, to reach a conclusion on something. And also, it's important to note that if there is substantial evidence both in favor or against something, it is the hearing officer's determination to choose between those two conclusions. You can have substantial evidence supporting a yes or a no on something. The hearing officer's job is to make that choice. If this board determines that there are substantial evidence to support either a yes or a no, then it would be proper to uphold the hearing officer's determination, because what this board function is not to second guess the hearing officer, it's just to determine if the decision that was made by the hearing officer was supported by evidence. So thank you.
Proceed, Mr. Wright.
Well, like you said, I bought my property and I ended up replacing the fence. At the time that I replaced my fence, I wasn't aware that there was a limit or anything to the height of the fences. One of the things that was brought up initially when I came was if this was analogous with the neighborhood. There's nothing uniform to the neighborhood as far as fences are concerned. So if you go down the street, there are people with fences that were almost as high as mine, if not as high as mine. You go elsewhere, I mean, so as far as whether it or not it's uniform to the neighborhood, that wasn't the case. The fence was put up without knowledge that there was a limit to the height of fences, just like I said, because, you know, when I came in, I saw fences of other heights that, especially in the area, that were comparable to the height that I had. So initially, there was a wooden fence that needed to be replaced. I bought the property due to the fact that I knew that it would be raising in value. And at this point, you know, getting the curb appeal up was one of the things that would help with that. So that's kind of where I am. And it was actually more than just even the curb appeal. I happen to live across from a skate park, so that means that there is a lot of traffic, whether it be foot traffic or people on skateboards, bicycles, or scooters. That means there's also a lot of traffic for homeless people as well. I live around Hillsborough and Sheldon, and there has been many homeless encampments around the Hillsborough area around there. Due to that, there at one point was a guy that was literally sleeping on the mattress less than a mile up the road from me. And that is one of the major reasons why I decided to put the fence up as well, because I have a 5-year-old daughter. And the last thing I want to do is have her playing in my yard and something to happen. So like I said, it wasn't my intention to break the law or anything like that. It was just my intention to up the curb appeal and up security. Not really sure what else there is for me to say. Thank you.
Does any board member have any questions of Mr. Wright at this time?
I've actually got one from Mr. Clark. If we vote to send it back to the land use hearing officer at that time, can the appellant then introduce new evidence to support his case?
Yes. The short answer to that's yes. If you're going to remand it, you need to identify which provisions, which of the 6 variance criteria that you want the hearing officer to focus on. In instances where none of the 6 are met, then the hearing officer is going to look at all 6. But if you also, I think this came up last time, but for the benefit of new members, there are 6 variance criteria. If a hearing officer found that, say, 4 of those were not satisfied, in order to send it back to the hearing officer, this board would have to find that the hearing officer's determination was not supported by consequential evidence on all 4 of those. So for instance, if this board found that in 2 of them, they don't think there was consequential evidence, but on the other 2 there were, in the end, that would still result in a denial of the variance before the hearing officer, because an applicant has to satisfy all 6 of the variance criteria. And so if this board wishes to remand it, you just make specific findings as to each of the criteria that you wish to send back to the hearing officer. Thank you.
Thank you, Mr. Clark. Does anyone else have any questions of Mr. Wright?
I have. Mr. Wright, thank you for coming. Can you specifically tell the board, for the other residences on that same street that are facing the park, can you tell us, do any of those properties have fences above 4 feet?
Directly across from the park? No.
Yes.
There are people, so there's another property that is, I believe the street is Robin Hood Drive, which would be butted up basically against the park. There's a house there. Their fence is about 6 feet high. There are other fences down that street as well, getting closer towards Sheldon, where the fences are higher than mine. Not higher than mine, but as high as mine, excuse me. As far as directly across from it, it depends on what you mean by directly across from it, because there's also properties that are adjacent to that park as well. And when I say adjacent,
let's focus just on your side of the street. So you're directly across from the
Yep.
park. Your neighbors, the rest of the houses on that street, any of them have any fences over 4 foot high?
So if you were to look to the neighbor to my right, which is, they have a wall that's between us, that is on our on the property line. They put that wall in. That wall is the reason why that fence actually ended up 6 feet high, because I matched that wall to where that fence ended. So that means that wall is pretty much about less than 10 to 15 feet, if I remember correctly, from the street. So that wall in itself was a big nuisance as far as me exiting, or it still is a big nuisance anyway, as far as me even exiting my property, because it's a big blind spot. But that wall has kind of always been there. They have the same wall on their other side of the property, and then up in there, they have their driveway, but they also have a 6-foot fence butted up against their house in a sense. But it's not as close to the street as mine is. So
what is the height? So is their front fence over 4 feet?
yes.
So,
But they have a driveway that is, and that's because they have their backyard set up. The way their driveway is, they've got a driveway that's a U. And they've got parking in front of their house, and then they've got a fence to fence off the rest of their backyard.
okay. And one more question. And how much of a security difference would a 4 foot versus a 6 foot fence make?
It's easy to jump a 4-foot fence, unfortunately.
No further questions.
Mr. Wright, I have a couple of questions for you. Regarding your neighbor and that wall,
Yeah.
that wall is set back from the street, as you said, 10 to 15 feet, correct?
No. It's less than 10 to 15 feet from the street. Where my fence actually starts is technically a couple inches back from the wall, because I have it centered in the center of a column.
Okay,
So that column is technically even further forward than the fence is. So
but those are side fences?
yes, exactly.
Okay, so correct me if I'm wrong, there is no one adjacent to you with a greater than 4-foot fence at your distance from the street in your immediate vicinity?
No, no. Because my neighbor on my left, they have a what? They have their drain field in the front of their house, Then they've got a tree line where their fence is kind of butted up against a tree line that they use to kind of.
Okay, but that's not right near the sidewalk or not near the
Exactly.
park? Okay. Second question is, you mentioned a homeless person on a mattress a mile away. And in the record, I saw that you mentioned an occasional trespasser.
Yes, I have had people, so that is because I have a 1995 Nissan 300ZX that, up until that point, I'd pretty much been driving. I had a dead cylinder on the car, so I let the car sit for a while before I go and decide to pull the engine and take care of all that. I've had people come into my yard to ask about that. I've had people, when I've left to Jamaica, that have literally been in my yard looking at things when I wasn't around. If it wasn't for the fact that I have a Ring doorbell camera that alerted me to that, I would have never known that anybody was even in my driveway.
Okay, I guess my question is there any police record on these incidents?
I was in Jamaica at the time, so I couldn't even make a police record. I wouldn't even been aware of what to do at that point. I
Okay,
mean, my
so-
family is all the way out in Plant City, and I probably could have called them, but by the time they would have got there, it would have been a moot point.
Okay. Have you suffered any vandalism due to intruders with the original fence, which I believe was what, 3 feet?
No, it was 4 feet.
It was 4 feet.
Yeah, it was
Okay.
about 4 feet, yeah. I didn't actually see or deal with anything like that, but at the time, like I said, when I got into the house, it was probably about 3 to 4 months or so after that I put that fence in. I work from home a lot of the times, but there are also times where I do go, I go into the office. So there's been, I can't necessarily say that what goes on when I'm not there. But I haven't had any issues per se as far as anybody vandalizing the property. I've had things left in front of my house, whether it be, like I said, scooters where I don't know if somebody's stolen something and just left it there. So there's a lot of little things like that that I've had to deal with as far as trash, X, Y, and Z, as far as, being left around there.
Okay, thank you. Does any other board member have any questions of Mr. Wright?
My name is Sarah Malkin. I have a question for you. You mentioned that you were aware of other homeowners who have received variances.
I don't believe I cited some of the fences that I thought, had probably gotten variances just due to them having it. There are 2 people that I know that I wasn't able to cite. And in fact, they've kind of told me at this point, with me having the code enforcement thing, that I should apply for a variance because they had already gotten a variance for this. And like I said, I wasn't aware that I even needed to do a variance or anything like that. I'm literally a first-time home buyer. So this was just something I decided to, hey, let me clean up my yard. And my fence looked like crap, so it was time to replace it. I happened to get a good deal on about $5,000 worth of materials. And let's put it this way, the labor that was out there doing it outweighed the cost, so.
Are there any other questions of Mr. Wright? All right, thank you, Mr. Wright.
Thank you.
Ms. Rodriguez, is there anyone else here to speak on this case, please?
No, sir.
You can be seated.
Okay.
Thank you. All right, board, you have heard the evidence from Mr. Wright. Actually, Mr. Hisney, is there any, as Development Services, do you have anything to add to this, please?
No, ma'am.
Thank you. All right, board members, you have heard the evidence presented, both from Mr. Wright and from the record. I would entertain a motion to either affirm the decision of the land use hearing officer or to negate the decision of the land use hearing officer.
I make a motion to uphold this decision.
Thank you, Mr. Schwartz. Is there a second? Now, hearing none, I will make the second. So we have a motion to affirm the decision of the land use hearing officer. Is there any discussion on this?
A couple things that I just want to bring up. If we uphold the decision, what would be his next step? Is there a waiting period at this point, or can he immediately reapply?
No, well, legally, the next course of action would be he could somehow challenge it in circuit court. This is the end of our appellate process internal to the county. As far as the waiting period to reapply, is it the 1 year? It's 1 year from the date of the upholding of the decision.
Their decision.
Today. Yeah. So unless there's an application that is significantly different enough that it would qualify as a different type of variance. But if, for instance, a variance for the same fence, there'd be a 1 year waiting period.
So if we were to send it back, it would essentially make the process a little bit easier, perhaps on the appellant's side, to present new evidence to support his case.
It would, yes. The record would be opened back up and evidence could be presented. The only thing I would say in regards to that, though, is that the primary function of this board is not necessarily just to give someone a second bite at the same apple. This body is supposed to review if there was competent substantial evidence presented initially to support the hearing officer's decision. So in an instance of a denial, the hearing officer is saying on various of the 6 criteria that there wasn't competent substantial evidence to support the variance, the granting of a variance. For you to remand it, you would be having to determine that you believe there is competent substantial evidence in the record to support it, and you'd have to identify essentially the focus of the hearing officer's remand hearing. So, and for instance, in this case, just for example, in the first variance criteria, are the alleged hardships or practical difficulties unique and singular to the subject property and not those suffered in common with other properties similarly located? And the hearing officer ruled no, the subject property is similarly shaped and situated as other properties. Essentially that there's nothing unique about this property that gets a variance. So in the instance of a remand, you would have to determine that in fact there was evidence before the hearing officer. If then it's remanded, the appellant and any other interested parties can enter new evidence into the record to address the 6 variance criteria.
Okay, thank you.
Is there any other discussion on this matter? Ms. Kennedy?
Shannon Kennedy, if we uphold it and he has to wait the 1 year between now and reapplying later, would he be considered out of violation, like out of compliance? And would he be penalized or anything of the sort?
Yes, so any present encroachment or structure that violates provisions of the code is subject to code enforcement citation. Similarly, I would say regarding other properties in his vicinity, if any of them have encroachments or constructions that violate the code, those are also subject to code enforcement citation. So there wouldn't be some sort of a waiting period that, yes, at present, a variance has been applied for. Oftentimes, code enforcement will defer enforcement of a provision pending the conclusion of a variance application. But yes, it would be subject to code enforcement at present, yeah.
Let me point out that the property is already under code enforcement citation. So if the board here does not remand it, what effect that will have on the code enforcement process is determined by code enforcement.
Thank you, Mr. Hisney. Is there any other discussion on the matter? And I will call for a vote. Ms. Lawhead?
Yes.
Mr. Schwartz?
Yes.
Mr. Baquerizo?
Aye.
Ms. D'Amico?
Yes.
Mr. Hind?
No.
And I, yes. Oh, what did I miss? Oh, Ms. Kennedy, sorry about that.
Aye.
So it is 6-1. The motion carries to uphold the land use officer's decision. Ms. Rodriguez, can you please call the next case?
Next case is on page 4. It's a new case, item 1A, appeal number APP 230280. The petition file number is variance dash double S 221530. The appellant and the owner is Josve Ruiz Capote. The representative is Luisa I. Alonso. The petition request is to appeal the decision of the land use hearing officer who denied the request for a variance of a 24.5-foot reduction of the 30-foot wetland conservation area setback to allow a remaining setback of 5.5 feet to accommodate the existing paver area and to allow the existing 6-foot high PVC fence to remain within the wetland conservation area setback. The location is 13729 Country Court Drive. The folio is 3030.5058. The size of the property is 0.25 acres more or less. The existing zone is RSC-6. The future land use is RES-4. The urban service area, is urban, and the date of the land use hearing officer was January 23rd, 2023. And did you take the oath?
He is the owner of the property.
Okay, he needs to take the oath. Raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Your name and address for the record, please.
My name is Josvani Ruiz Capote, and my address is 13729 Country Court Drive, Tampa, Florida, 33625.
Okay, and each of you that will be testifying have to state your name and address for the record as well.
Yes.
Okay. Okay. Yes, my name is Luis Alonso.
Speak into the mic.
My name is Luis Alonso. I am the agent for Josvani in these papers and documents that we put in for the application for
Your
the
address?
The address, my address is 1103 Terramar Drive, Tampa, Florida 33613.
Sir?
Yes, my name is Jorge Camarota. I'll be assisting Luis Alonso because the language barrier is kind of hard, so I'll try to help her as much as I can. And my address is 7345 Abonado Road.
Thank you.
Él lo dijo ya.
Ya le dije mi nombre.
Again?
Again, name? Again, the name?
No, he already said his name. Yeah,
Okay,
we're
thank
good.
you.
Go, yes, okay.
Please proceed.
Yes, we appeal to this decision that he putting a PVC fence 6 feet high with pavers in the backyard for the reason that he get the property and immediately he made this for the property. But before going to making any job in the site, he went to Hillsborough County Building Department to asking if he needs some permit. And normally in Hillsborough County for PVC fence and pavers in the property, is request a permit. In this case, nobody asking to him, bring a survey to review if there are any wetland or something. He didn't know because he is first buyer, and he didn't know that the wetland existing in the property. And immediately he put in the pavers and the fence, code enforcement coming and put the case, and he made the application, but was denied. All the time say that he know that was impossible to put in the fence and the pavers. In this case, he needs the pavers and he needs the fence because he has 3 little boys, and it's only the space that he has for the backyard because the other side is the small side that he has in the area, and it's the area that they enjoy for the backyard. In this case, we propose the planting compensation for the area that he take from the wetland, and at least that permitting to him putting the fence is in the 30 feet, at least in the 15 feet from the wetland protection. That is that we are coming today again asking for that.
Does any board member have any questions of Ms. Alonso?
Shannon Kennedy, when you purchased the property, was there a fence or pavers or any other items in that area?
Cuando compraste.
¿Alguna fence seca o había pedido o algo ahí en esa zona?
No, no, no.
Thank you.
Ma'am, Daniel Bacariso on the board. When the property was purchased from the owners, were there any communications about, if there wasn't an existing fence, any communications about wildlife or things encroaching on your property from the adjoining wetland?
Sí, cuando compraste la casa, tú preguntaste a los dueños si había visto algún animal, que eran animales que habían venido del mercado wetland.
Los vecinos me dijeron que habían visto un alligator afuera de mi casa.
So I'm going to start what he's saying. So basically what he's saying is he spoke with the neighbors and the previous owners and said that they saw some animals, especially a gator, in the area. So that's pretty much why he decided to put the fence and the pavers.
Y hace reciente han visto coyotes y osos que están en las noticias del 92.5.
And he said that also there's been sightings of coyotes and bears in the area as well.
In the notice.
And in the news already, they show something about
In
those
that
sightings.
in that neighborhood or around that neighborhood?
Around the neighborhood, yeah.
Okay. And what kind of PVC fences can look very different? How does this particular how is this fence set up?
The fence is the similar fence, white, PVC white that you see in every lot of houses is typical that don't request any permit in the building department for putting the fence. The fence is only 4x4 columns and the panel in the middle with PVC. And at the bottom, there are a little about 2 inches from the pavers to the fence.
Okay. Are there any gaps between the slats on the fence, or is it just a solid piece?
It's solid, and he has only a door at the front.
Okay. And so how much of the fence is actually in the ground? Just columns, just each of the columns in, but there's a gap from the ground?
The gap is 2 inches.
Okay.
So my question would be this: if you had small children and alligators and other creatures can be found in any body of water, fresh water in the state of Florida, why did you buy that? If I was concerned, just my own opinion, if I had small children, I was worried about them being near the pond. When I was looking for a home, I don't think I would have bought one.
Cuando yo compré la casa, yo vi que todo el mundo tenía cerca. Y yo dije, compro mi casa y pongo mi cerca. Si todo el mundo no sabía nada de wetland.
Okay, so he's saying that when he bought a house, he saw that everyone in the neighborhood had fences. Mm-hmm. And he thought it was appropriate for him to just buy the house and then just put the fence. Again, you're stating that to protect his kids.
Now, correct me if I'm wrong, on that 30-foot setback from the actual wetland, that would occasionally flood.
Se inunda cuando llueve.
De ese lado un poco.
He says it floods a little bit, not that much.
Okay, so then the setback is actually doing what it's supposed to do by absorbing the excess water.
Que sí, que sepa que está haciendo lo que necesita hacer. Porque tiene que superar agua.
Does any other member have any questions?
I have a question. On our document, on page 80, I see an email from Luisa Alonso that states that the original survey was being sent. Is that in our packet? And on the original survey, when you purchased the house, did that show the 30-foot wetland setback?
The original survey that was knowing this, the wetland setback. When you buy the property, only the survey that gives to the owner is the boundary survey, no any additional information, no elevation, no any trees. He gave the survey only with the border of the boundary, nothing more information.
Okay.
For that reason, when he get that paper, he say, I saw that and I went to asking for putting the fence and the paper, and he didn't know. He know that when the code enforcement come into the site and say to him that that is a wetland.
Okay. Now, again, was the original survey included in our packet?
I'm not really sure, but I know that there is one on page 69.
I have here one sample for the, similar to the survey, where is the delineation for the wetland, where is the fence, and at least that
Board-
permitting to
Yeah,
him
board members,
15
let's
feet.
confirm that it's in the record, so.
It looks
ma'am,
like
you
it's on
could-
page 7.
Okay, yeah, and that's all you need. If it's in the record, you're good.
Just, that's just what I want to see, that if he had any delineation on his original survey of any wetland, which apparently there is not from my review of it.
Shannon Kennedy, were there any impacts to vegetation or removal of any vegetation in that area to put in the fence and the pavers?
De esa área no, solamente había hierba y bushes.
So it says when he put the pavers in the fence, there only were like grass and little bushes. And also on the previous variance, we also include a planting
compensation.
compensation if it was required.
Follow-up question. If you were to move the fence and pavers from where they're at now to meet that 30-foot setback, how much distance would you have between that southeast corner of the existing residence and then where the fence would be at the 30-foot setback?
If he moving to the border, there are no space for passing. It's only 2 or 3 feet, 2 feet, no 3 feet. That is the minimal passing. That is at least 15 feet from the wetland protection. Remain when the fence is something that is better, that not completely open.
Okay, thank you.
I have a quick follow-up question. I have a quick follow-up question. Sir, you were saying that all the other properties in the neighborhood that are adjoining to one of the wetland areas, all of them have fences?
Only 4.
Yeah, I have a picture too. Let me show you.
Hang on, though, no pictures can come in now that weren't before the hearing officer. This isn't a new hearing, this is an appeal, so if those pictures or if they're already in the record, you're okay.
I have the folio number for the other property next to him and here that has things.
Was all that stuff testified to before the hearing officer? Or is this the first time that you're addressing this?
He's asking the question.
No, I know, I understand, but so one of my main functions here is to make sure that nothing comes before this board that the hearing officer didn't get to consider. So basically, the way it kind of works is, at the end of the hearing officer hearing, the record is kind of locked, it's sort of frozen in place, and this board can only consider what the hearing officer saw.
No.
Okay.
Que si habíamos enseñado esto anteriormente. No. Pero no.
Mr. Hazen, I have a question for you. All of the information I see on 67, 68, 69 appears to be amelioration work after the fact. I don't see this as being the purchase survey. If the purchase survey is in here, could you please identify it?
I believe the purchase survey is on page 62. without going in depth in the record and trying to match up. But the survey on page 62, I believe is the purchase survey, but
It also looks like page 70 has the
70
original
has the
survey.
same one? Okay. Yeah, well, yeah, it's PDF page 62. Let me see what it is. Numbered on the bottom. Let me see. Yeah.
1.A.69.
Yeah, I'm trying to scroll down to see it. Yeah, 1A, I think it's 61.
So the original survey would be 1A61,
I believe so, yeah.
and there is a note on the right-hand side of parcel A drainage easement.
Oh, yeah. May I ask, was there a fence up at before when you bought the property or no? There was no fence? Okay.
Se había cerca antes de que tú compraste la propiedad.
No, no.
I have I suppose, a background question that May Development can speak to as otherwise. Are these pavers and this fence covered by the Land Development Code section that we're looking at, B4? Because the fence does not appear to be impervious, and the pavers are specifically semi-pervious. So I don't see any determination in the land hearing officer's decision about that. So if either could speak to that. Am I correct that the fence is not an impervious structure and the pavers are semi-pervious?
Pardon? I'm sorry, can you repeat the question?
Sure. We'll start with the fence. Is the fence covered by this code section about placement of permanent structures and other impervious surfaces?
Yeah, so actually, this is a wetland setback variance, so the report was prepared by Natural Resources staff, and we have Carla Shelton Knight in attendance virtually, who is on hand to answer your questions regarding this variance.
Hello, this is Carla Shelton Knight. Can you hear me?
A little louder.
We can hear you, just a little bit louder.
Okay. I am the reviewer, or the manager rather, for the Natural Resources Review Team. And this section of the code is something that my team deals with. So 4.01.07 B4 explains what is allowed within a 30-foot setback per the code, and anything not listed requires a variance.
I understand that, but it's specifically saying no permanent structures and no other impervious surfaces.
Correct.
So is a fence a permanent structure or other impervious surface?
A fence is considered a permanent structure.
Okay. All right.
And the part about the pervious paving, the wording says the limited use of semi-pervious paving material. And it was determined that filling the majority of the 30-foot setback with the pavers was not limited use, and therefore required a variance.
Okay, and I guess what qualifies as a limited use of semi-pervious paving versus what's at issue here?
That would be a gray area, based on the way the code is written. But because the pavers encompass the majority of the 30-foot setback, it was determined that it was not the limited use.
Okay. All right, so that answers that's how that determination was made. Thank you.
Ms. Knight, this is Ricky Bauman, the chair. What would you consider to be an example or examples of limited use in the setback?
What staff would consider to be limited use.
Yes,
Sorry, I
please.
have a really bad echo here. So what staff would consider would be no more than halfway into the 30-foot setback. So no more than 15 feet into the 30-foot setback.
Thank you. Does any other member have any questions of Ms. Knight? Does anyone else on the board have any questions of the appellant?
This is Clara Logan. I have a question for you. It appears that to the west, to the right of the, there appears to be a body of water. Is that correct, that there's a body of water?
Why? So we're exactly where, okay.
You see this?
¿Qué dice, papá?
We're looking at page 1A63, which highlights the plot.
Que si hay agua ahí. ¿Hay agua ahí?
This is a drainage easement. Is in this is no exactly my property. Maybe 10 feet or 50 or 15 feet.
Please,
drainage easement.
please speak into the mic. Speak into the mic.
Oh, sorry. Next to my house, I have a drainage easement at 15, maybe 10 feet or 15 feet. Yes.
So that would be the triangle area on 1A63. So if you're looking at 1A63, the red area is the property in question. The triangle directly to the right is that drainage easement.
And I guess, one quick follow-up. I guess the question was, is there a standing lake or creek there, or is it just an easement that sometimes gets flooded?
Solo a veces. Ahora mismo está seco. Pero llovió ayer y tiene un poco de agua.
So it says every time it rains, it gets flooded. Not flooded, but like water accumulates in there.
Okay, that answers my question. Thank you.
Does any other board member have any questions of the appellant? Thank you, Mr. Alonso. Thank you.
Thank you.
Thank you.
Does any board member offer a motion to affirm or deny the decision of the land use hearing officer?
I move to deny the land use, or Daniel Baccariso. I move to deny the land use hearing officer's decision below. There's competent substantial evidence that the property use would be has unique difficulties based on how much the wetland encroaches, and there's some issues about whether the pavers themselves run afoul of the land code provision. I'm not sure that I agree with the interpretation of the limited use of semi-pervious paving. Thank you.
Let me
I'm sorry.
clarify the.
Okay, go ahead. I'm
What the
sorry, Matt.
motion would be. I got it. Trust me. Either we're going to affirm the decision of the land use hearing officer, or we're going to remand it to the land use hearing officer, and we're going to have to specify which of the 6 criteria that we want the land use hearing officer to review. Otherwise, we can't remand it. We have to say what we have in mind that we think was not taken into consideration.
And one other issue I'd point out is in section 1005 of the Land Development Code, which governs appeals, there's 2 separate appeals processes. The one that we're here before today is when the land use hearing officer hears a variance or a special use, and that determination is made, that can be appealed to this body. Now, regarding interpretations of the Land Development Code, which is what Ms. Shelton was describing to you and what you described in your motion, there is a process for appealing interpretations of the Land Development Code. The Land Development Code, the responsibility for interpretation is the county administrator. The county administration, other does a designee, which in this instance is Ms. Shelton, is the designee for that type of interpretation. There is a process for appealing interpretations of the code. It's just not this process. Staff's interpretation can be appealed to a land use hearing officer, and just so that you know, it's actually the same hearing officers that do the initial determination. In this case, it's a different process. It's a different function. So for purposes of the hearing today, this board is not able to question interpretations of the code. Staff is responsible for interpreting code, and those interpretations can be appealed to a land use hearing officer if someone wishes to do so. So you can certainly make a motion to, and as the chair stated, the motion would actually be to remand it to the land use hearing officer, and you can determine, that there's substantial evidence, and it looks like there's 5 of the 6 criteria were found not to be met. You can point out piece of evidence that you think satisfy various criteria, but as far as disagreeing with the interpretation of the code by the administrator, that's not what this process is for today.
So I need to rephrase my motion.
Well, yes, please.
Okay.
Either you're going to either you're going to affirm the decision of land use hearing officer, or we're going to remand it, but we have to determine which of the 6 criteria the remand would be on for them to reconsider.
All right. So let's clarify that then. All right. Motion to remand back to the land use hearing officer for reconsideration of, let's see, 1, 2, 4, 5, and 6. Those are the ones where found that doesn't qualify for a variance. And just taking them in turn, based on the record evidence, the setback makes it not possible to have a similar fence that other properties enjoy, and if the other properties are adjoining the wetlands also have fences, as is in the record, then I don't see how they come to the conclusion that this one would not be having unique hardships from not having a fence. If the other similar situation are having that benefit. 2, I believe one of the board members asked about where would the fence have to be if they kept to the setback, and it would be 2 feet, barely any walking distance from the house. So the literal requirements would make a fence nearly untenable. Let's see, substantial interfere, that's not it. 4. So how many cars are there? Yes, the in harmony and variance serve the general purpose. If they have in the record, there is a compliance plan of adding additional vegetation and foliage being planted. And for that reason, also number 6, it would result in substantial justice for the plan under number 6. I skipped number 5, I'm sorry. Let's see. Additional findings on whether it resulted from an illegal act or results by the applicant or property owner. Apparently, it's not on the survey. It was not provided. There was no information provided in the permit office. There's nothing. It's not clear from the record if there's anything else that the owner could have done additionally to find out about this wetland, and so an additional remand as to what else he could have done that wouldn't have been to make this a self-imposed hardship versus just the proper bodies did not tell him what he needed to know about his own property.
So your motion is on 1, 2, 4, 5, and 6. Am I correct? Mr. Vaquerizo?
Yes, it's not on 3 because that's not an issue. 1, 2, 4, 5, and 6. Yes.
Okay, thank you. Is there a second to the motion?
I'll second it.
That's Mr. Hind. Is there any discussion on the motion? So this is a motion, yeah, please.
Maria Elena D'Amico here. In reading it, I did see that there were other variances granted in the neighborhood for similar situations. Is that, so I guess my question would be, in connection to yours, would there be some other way that they could possibly maybe not go the whole 24 feet, but lessen it and make it easier?
Well, what I heard from staff was that due to the large encroachment of the setback, that they felt that the variance should be denied because they were going far into it. When I asked about the limited use, and so the answer was less than half.
Okay.
Now, however that works out, that's beyond our scope.
Sure. Okay. Thank you.
Adding to that, I believe in the record are the variances granted were actually for, actual structures, like in addition to a property and to the actual paved area. So the grants were to much more significant encroachments on the wetland than semi-pervious pavers and a fence. So I think that should be put into consideration.
Well, what I want to say about any other structures or any other properties, unless they're shown to have an impact on stormwater and drainage, we do not have the expertise as a board, nor should we try to second guess staff, because that's their job. Our job is simply to make sure that substantial justice is done in accordance with Hillsborough County regulations and things of that nature. Staff is going to be expert on those type of things, and whether someone suggests to remove part or add part or ameliorate a condition with plantings or things of that nature, that's way beyond anything that we can possibly do or understand, because we're not scientists. And we're not geologists, and we're not experts on hydraulics. So that's way beyond our scope as a board. The only thing that we can discuss is, again, are these 5 criteria, 1, 2, 4, 5, and 6, do they need to go back to the land hearing officer so that they need a review, or does the appellant need to actually go to another forum and work their difficulty out otherwise? Because if we're going to send this back to the land use hearing officer, and Mr. Clark, you correct me if I'm wrong, the variance will only be granted if all 6 are fulfilled.
Yes, that's correct. But I believe one of them was excluded because the hearing officer on, I believe it's number 3,
yes,
would the variance, if allowed, substantially interfere with other properties, and the hearing officer found that no, that it would not. So that's effectively stating that this applicant satisfied that criteria because there's no adverse impact on their property owners. So in this instance, it was denied because 5 out of the 6, 1, 2, 4, 5, and 6. So there would not be additional review of criteria 3 below because the hearing officer already found that one to be an affirmative. I realize it's getting confusing because it starts with the word no, has an affirmative finding say no, but in fact, that is an affirmative finding. The question is whether the variance, if it's allowed, would substantially interfere with the rights of others whose property would be affected by allowance of the variance. It says there's nothing in the record to state that that's the case. That's an affirmative finding.
So we have a motion on the floor to remand the case to the land use hearing officer on criteria 1, 2, 4, 5, and 6. Is there any more discussion from the board on this motion? Hearing none, I will call for a vote. Ms. Lawhead?
No.
Mr. Schwartz?
No.
Mr. Baquerizo?
Aye.
Ms. D'Amico?
Yes.
Ms. Kennedy?
Nay.
I'm sorry, Ms. Kennedy, I didn't hear you.
No.
Mr. Hine?
Yes.
And I know, I believe that becomes 4-3.
Fails 4-3. So that wouldn't be dispositive. I would then suggest there would, if the motion to remand has failed 4-3, I would recommend someone make a motion to uphold and see how that vote goes.
Is there any board member willing to make a motion to uphold the decision of the land use hearing officer?
I make a motion to uphold.
Is there a second?
Clara Lowhead, yes.
Is there any discussion on the motion?
I would like to discuss a few things.
Please.
Under number 1, are there alleged hardships or practical difficulties unique and singular to the subject property and not those suffered in common with other property similarly located? When we looked at the aerial map, this is the only property that I saw in that immediate vicinity that had that much wetland on its site. The takeaway I have is that within 2 feet of their structure wall, the wetlands begin. Because it's unique, that is something that I'd like for us to discuss a little bit. Then I want to go to number 2. Would the literal requirements of the LDC deprive the property owner of rights commonly enjoyed by other properties in the same district and area under the terms of LDC? I do not see that the owner is deprived of any restriction other than which has been produced by building a home on top of the wetlands. But that is not depriving the owner of rights commonly enjoyed because this property is unique. Then we've skipped number 3 because we see that that is already in place. Number 4, is the variance in harmony with, and does the variance serve the general intent and purpose of the LDC and comprehensive plan? To encroach into the wetlands clearly goes against the intent of the comprehensive plan and the land development code. Number 5, does the situation sought to be relieved by the variance result from an illegal act or result from actions by the applicant or property owner resulting in a self-imposed hardship? I would say it's not the owner of the property that has the self-imposed hardship, but the builder of the original home that has created a self-imposed hardship. I say these things for further discussion. Excuse me, I forgot number 6. Will allowing the variance result in substantial justice being done?
considering both the public benefits intended to be secured by the Land Development Code and the individual hardships that will be suffered by a failure to grant the variance. The property owner did purchase this property knowing that there was wetlands plainly visible. And to now ask for a variance to address something that was known, it makes me think of buyer beware. Thank you.
Does any other board member want to discuss any of these criteria?
Shannon Kennedy, on 1.A.43, it indicates that the property owner requested a wetland delineation by EPC or requested it to EPC. Did they complete one, or did an outside third party complete one that's an updated wetland delineation?
Carla?
Hello, Carla Shelton Knight. I am looking through the original record to see if I can see who did it. And it looks like it was EPC.
And that was completed in the last year or so since he purchased the property in May of 22?
Hold on, it's not opening on my computer very quickly. Well, unfortunately, I can't get the EPC survey to open up in my program. Try it one more time. Okay, here we go. It was completed in October of 22.
Okay, thank you.
Is there any more discussion on the motion on the individual sections?
I suppose then, going in order as a board member pointed out, just going at it one by one. Number one, as pointed out, this seems to be the only property that is actually situated this close to a wetland and specifically to this wetland. So it would be, I think, a very difficult finding to say that this is not a unique and singular hardship because it's the only one that has this particular hardship. So as far as number one, that seems to be at least one basis for saying that it's disagreeing with the finding of the officer. Let's see. For number two, since this is built as a residence, I'm not sure I understand the commentary about you can use the property but not as a residence. Can you explain a little bit about what you were suggesting with that?
Yeah, I certainly wasn't, I was concerned from the concept of the builder building that close to the wetland, leaving him no backyard. and so I didn't say it couldn't be a residence, but why would a builder build that close to the wetlands and leave no backyard? It should have never been approved, perhaps, in the first place. But it is unique, as you said, when we look at the aerial.
Certainly, and from what the owner remarked, or from what's in the record, it would be about 2 feet if they were to put any kind of fence there that's consistent with the setback. So I'm having a hard time. It would be difficult to find that you are enjoying your property that you've purchased in the same way as all the other residences if most of your property is to be fenced off really close to your house. Let's see, number 4, variance in harmony.
May I suggest we go one by one, because by jumping around, we're just going to get confused. So let's talk about number 1.
All right, I'm happy to do that, sure.
Okay. Number 1 has a house, it has land, it has the beauty or lack thereof, or functionality or dysfunctionality because it is on a wetland. That is actually a special thing. It doesn't make the property unique because there are many, many, many homes with pie-shaped lots in our county that have these type of things. The county does not guarantee to any homeowner an area of their selection for pavers, for a fence, or for any other additions. What the county does when they plat the land is, this is the plot, the builder builds it, makes the applications, and so on and so forth, and that's what you've got. Doesn't matter if it's right, it doesn't matter if it's wrong, but this is a good-sized, odd-shaped lot. It just happens to be on a wetland, and where they chose to put their fence and put their pavers is their choice. But there's no guarantee that for any homeowner that you can get everything that you want or the way you want it. There are regulations. As you heard from Natural Resources, had it been less than half the setback or whatever, that might have been approved. Again, we can't second guess the scientists, that's not our job. But is that property so unique and so different that we're going to say, okay, yeah, it's okay, just go ahead and do it? I don't have a good answer for that. I really don't, because I'm not the expert in zoning or in land use or in stormwater, wastewater. But the point of the criteria is, did the land use hearing officer take the proper criteria into making the decision on that, or what did they not take into consideration? You know, this, however the builder built it and whenever it was built and whatever the size of the plot is and the boundaries, that is way beyond us. That's history. Is there any more discussion? Okay, let's go to number 2. Any board member like to discuss the decision on number 2?
This is Clara Lawhead. I just want to say that I believe the intent of the land use code was to protect the environment, and it should apply to all properties because there's a hardship that was created previously, should not reduce the importance of preserving the established land use code.
Hearing no further discussion, let's move to number 4, because number 3 was not an issue.
Okay, since we're now on number 4, Daniel Bakary, so I would point out that suppose being in harmony and serving the general intent does not exclude variances. Being in harmony with the plan cannot mean that no variances are granted. Otherwise, why are we having a variance procedure? It's the underlying is some variances do still serve the purpose of the plan and the code. So protecting the wetlands and drainage is the intent of this. Then if the owner has a plan to minimize the impact he has on the wetland and compensate with other foliage, that would seem to be indeed a variance from the literal plan, but still in harmony with that plan. And if the I'm not sure I have in the record, what was the compensation plan was made in between the owner and what other body? I think I missed that in the notes. If someone could point out where was that?
Ms. Shelton Knight, can you please comment on that? On the compensation plan vis-a-vis the existing encroachment?
Yes, the compensation plan needed to be an equivalent square footage of planting compared to the amount of square footage of encroachment. If I remember correctly, this one was less than the total, just due to limited planting area left. And staff did accept that they had planted as much as they could on the site. Or not had planted it, but proposed to plant it.
So if I'm getting it correctly, the compensation plan was not acceptable?
It did not meet the criteria of equivalent square footage, but because there was limited room to plant on the property, staff accepted the planting plan as it was submitted.
Okay, thank you. So the compensation plan, even though it didn't have sufficient square footage due to the lack of actual available land, was acceptable to natural resources. Ms. Kennedy?
Shannon Kennedy. If they were to remove the fence and utilize native wetland vegetation as a barrier in place of the fence and then removed the pavers so that it met the limited use of semi-pervious, would that be a viable option?
Well, we're trying to reinvent the wheel with that. That may be a viable plan, but that's going to have to go through a different process. Our job is to say, okay, this is what's proposed, this is what is, and do we say, yes, the land use hearing officer is correct and deny the variances, or we remand it, but only where the land use hearing officer didn't take certain things into account. We're not talking about changing the plan that they have. That's beyond our scope.
I guess then the only, Daniel Bakary, I guess then the only aspect of that would be relevant for us here is there any other acceptable plan other than greenery over that entire property? Was it Mitchell? No.
Ms. Shelton Knight.
Shelton Knight, Ms. Shelton Knight. I'm sorry about your name. Ms. Shelton Knight. Were there any discussions of other proposed plans that would fit the limited use of semi-pervious or basically any other proposed plans with the property owners about what would be acceptable, short of putting the fence back at 2 feet from the house itself.
Well, I think we need to back up to how this case came to being. This was a complaint called in by a neighbor for filling in the rear yard. Our code enforcement team issued a citation for unpermitted activity in the backyard. This had already been done by the time our staff was aware of it. So he was ordered to either remove the pavers in the fence or to get a variance for them to be there.
So there are no discussions or communications with the owner about alternative plans that would be acceptable?
He did not propose any alternative plans.
Okay.
Is there any, okay. Is there any more discussion on number 4?
Just in general, I think part of the problem that everything evolved from is that on the original survey on page 70, while it says drainage easement, there is nothing that delineates or mentions a wetland. There's nothing that states that there's a setback on that property. You know, buying a home, you know, unless it is explicitly stated, you know, and I'm versed in this matter, I wouldn't know unless I did my own heavy research outside the realms of a standard homeowner. You know, if I'm looking at drainage easement, I mean, that could be a drainage pond, it could be a drainage swale, it could be a drainage stormwater pipe that runs through there. There's no indication that it's a wetland. And because of that, as a homeowner, if I don't have that information when buying the home, you know, I think it would be safe to assume that I could use my entire backyard in any manner that I so choose to, you know, erecting a fence that doesn't require a permit, putting pavers in that do not require a permit, and that's what I would do. And that's how I would interpret it based on the survey that is on page 70. I think that is what needs to be reevaluated, you know, to see if he is in compliance or if it can be reviewed to allow it to be in compliance.
Board members, the case did go before the Code Enforcement Special Magistrate, and it is now in compliance. He removed the pavers and the fence.
Oh. So, Mr. Clark.
So understand something, there's a distinction here. So what is being sought at this time is, presumably, the gentleman would like to put them back. So typically, very frequently, what this board receives is, you know, the old thing about it's better to ask for forgiveness than permission. This gentleman is actually here asking for permission because he has complied with the code by taking everything out. It doesn't change your analysis because the hearing officer's determination is still a denial for those five criteria. Motion is still the same, but in terms of paths forward, that is something that the gentleman could explore, assuming that this ultimately, the hearing officer's determination was upheld. But all Ms. Rodriguez is testifying to is the fact that there is no ongoing violation because the gentleman has removed the encroachments.
Thank you, Mr. Clark, and thank you, Ms. Rodriguez. That sheds a little different light on it. The other point that I wanted to make out is the survey. Yes, the survey should have the drainage areas and the flood area marked out on it. That's an issue between the homeowner and the survey company that did the survey. I will give you just no, I'm going to be quiet. I'm not going to talk about it.
And I'm not disagreeing with you. It's just, you know, if I purchased a house and I received the survey, I'm going to take that as a matter of fact that there are no limitations to my property.
Agreed.
Only until something is erected and somebody calls in a complaint after the fact, then it comes up.
Yeah. But that's where the owner has recourse to take that survey right back to the company and say, you owe me X amount of dollars because look at all the money I spent. Here's the bills. Here's the code enforcement. Here's the stuff from the county. Here's the variance I can't get. And it's all because you didn't do your job.
And that's
And
what
that's
errors and
beyond
omissions is
us.
for. And I get it, that's what errors and omissions is for.
After the meeting, I can tell you a story about the survey company. I
No,
can't
I
say
just-
it, I can't say it publicly, but
I would agree with the original vote that we send it back based on the evaluation of the survey. That there is no indication of any wetland. There's no indication of any wetland setback.
So,
Well,
board
well,
members,
right, hold on.
just for purposes of the record, the motion to remand failed 4-3.
Correct.
And I understand that.
So
We're having discussion.
No, I'm just saying
on
the motion on the
individual
floor
cases.
is to uphold. The problem is because of this board only has two options, uphold or remand. It really isn't even proper to do a substitute motion to remand because that vote just failed. So
Okay.
you're still pending you have a motion and a second to uphold the determination.
Okay.
okay, so anything else on number 5? Anything on number 6? Okay, I will call the discussion closed, and we will call for a vote to uphold the decision of the land use hearing officer. Ms. Lawhead,
With regrets for the party involved, the answer is yes.
Mr. Schwartz,
Yes.
Mr. Baquerizo,
Nay.
Ms. D'Amico,
No.
Ms. Kennedy,
Aye.
Mr. Hind,
No.
and I believe that is 4-3, which upholds the decision of the land use hearing officer. And that concludes our cases for today. And now we have minutes to approve, Ms. Rodriguez.
Yes. We have the April 6, 2023 minutes for approval.
Ms. Kennedy,
Motion to approve?
is there a second? Approve the minutes from April 6th?
I'll second.
Thank you. Is there any discussion on the motion to approve the minutes of April 6th? Hearing none. Ms. Lawhead,
Aye.
Mr. Schwartz,
Aye.
Mr. Baquerizo,
Abstain. I wasn't present.
Ms. D'Amico,
I guess I should also abstain. I wasn't here either.
okay. Ms. Kennedy,
Aye.
Mr. Hind,
Aye.
and I, the motion carries 5-5 affirmatives with 2 abstentions. Ms. Rodriguez, or we have any more business before the board?
Just to let you know, we have no cases for the July 7th, so we'll go ahead and cancel that. I didn't cancel it because I wasn't sure if anybody was going to continue a case to that. So the next scheduled hearing will be August 4th, and if that's canceled, I will certainly send you an email and let you know.
And having no more business before the Hillsborough County Land Use Appeals Board, I, Ricky Bauman, adjourn such meeting. Yay.
It's tough, yeah. Why do we have rules if we don't?